Hi, everyone. We'll get started in a minute just to give everyone a chance to join. Okay. Well, hello. My name is Jen Reynolds, and I'm a professor and associate dean at the University of Oregon School of Law. It's my great pleasure to welcome you to today's Oregon Law Perspectives. This perspective series brings the work of our law school's faculty to our colleagues, to our students, our alumni, and the broader public. Today, we are thrilled to feature two of our professors, Professor Howie Arnett and Professor Garrett Epps. Let me just briefly introduce them. Professor Arnett has practiced law for 40 years in Arizona and Oregon, representing tribal governments, tribal members, and Native American organizations. His law practice in Bend has included work for tribes on treaty rights, tribal sovereignty, tribal law development, government-to-government relations, water rights, and gaming. He has a bachelor's degree from Stanford, a master's degree from the London School of Economics, and a JD from the University of Oregon School of Law. Professor Epps teaches constitutional law. Before returning to Oregon this past year, for which we were very grateful, he taught at University of Baltimore Law School, Boston College, American University, and Duke. While at Baltimore, he was the magazine The Atlantic's Supreme Court correspondent for 10 years. He's a prolific scholar whose work has appeared in top law reviews. He has an LLM and JD from Duke University and an MA from Haaland College. Today, Professors Arnett and Epps will be discussing Brackeen v. Haaland, a case coming to the U.S. Supreme Court this fall. I won't go into any more detail on that. We'll hear what they have to say, but just quickly, for those of you who'll be seeking CLE credit, you're going to receive an email after this event asking for your bar number, and so then we can submit that for you to the Oregon State Bar. And with that, let me turn it over to Professor Arnett.
Thank you, Jen. What I'm going to do is just briefly describe in a few minutes where the Indian Child Welfare Act came from, why it was enacted by Congress in 1978. The background is pretty remarkable, really. A crisis in Indian child welfare affecting both Indian families and Indian children, as well as Indian tribes themselves. Then I'll explain a little bit about the act itself, how it works, and try to spend not too much time on that. And then go to the Brackeen litigation, where it started, what the claims were, how it proceeded through the district court in Fort Worth, Texas, to the Fifth Circuit, to a 3-judge panel, to an en banc panel, and then on to the Supreme Court. And then describe the lineup of parties and the rather amazing list of amicus filings in the Supreme Court. And with that, I'll then turn it over to Professor Epps, and he will, because he's a constitutional law scholar, and I just practice Indian law and teach Indian law. And he will talk about the constitutional issues, and then we'll really get into the discussion. So let me screen share here. I've got a few slides to help us understand the background, first of all, of the Indian Child Welfare Act. The statute was passed in 1978, and it was identified as a response to a crisis in Indian child welfare. And the statute has congressional findings as part of the statute that explains why Congress is doing this. And the first finding, or one of the findings, is the Congress described an alarmingly high percentage of Indian families are broken up by the removal, often unwarranted, of their children from them, their families, by non-tribal public and private agencies, And then an alarmingly high percentage of such children are placed in non-Indian foster and adoptive homes and institutions. So there's really an existential crisis regarding Indian families. Congress also went on to say in their findings that this is a crisis for tribes themselves, for the federally recognized tribes in the United States and Alaska. Congress understood the problem threatens not just the welfare of Indian children and their families, but also the continued existence and integrity of Indian tribes. So this child welfare problem is really an existential problem for the tribes themselves. They are losing members or losing children who could become members. The House report that was included in the legislative package as legislative history really begins to quantify the problem, and the numbers are pretty shocking. When the statute was being considered by Congress and enacted, the numbers show that somewhere between 1/4 and 1/3 of all American Indian and Native Alaskan children had been separated from their parents through the operation of state family law and through state courts. And just looking at some states with large Indian populations and how foster care placements and adoptive placements have been made and dividing them up between Indian children and non-Indian children, and there's some shocking disparities. Washington, adoption rate for tribal children, 19 times greater than the rate for non-Indian children. Foster care rate, 10 times greater for Indian children than non-Indian children. South Dakota, foster care rate, 16 times the non-Indian rate. Montana, foster care rate, 13 times the non-Indian rate for non-Indian children. And of these children that ended up in the state child custody proceedings, foster care and adoption proceedings, 85 to 90% of these Indian children in foster homes or adoptive homes were placed with non-Indian families. Well, what brought this about? And this is also one of the findings in the statute, and it's actually fairly gentle. The House report is a little more blunt. The finding in the statute says Congress determined that a major cause of the problem was that state child custody proceedings, quote, often failed to recognize the essential tribal relations of Indian people and the culture and social standards prevailing in Indian communities and families. The House report basically points the finger at state social workers and state courts and said they simply did not understand Indian family structures, any extended Indian families, how they work, and how, as a result of that, they oftentimes would find what they thought was neglect when there really was no neglect. And oftentimes they simply felt it would be better for Indian children to be raised by non-Indian families. Essentially, there were prejudice against the family structure of Indian families. So those are the reasons that ICWA was enacted. So here's the statute itself. Try to summarize this briefly. The target of the statute is state court child custody proceedings. That's the source of the problem, and that's the target of the statute. And what the statute does is provide certain procedural protections and raises substantive standards for involuntarily removing an Indian child from the Indian child's parents or legal custodians. And this doesn't apply to divorce cases, doesn't apply to juvenile cases. These are foster care and adoption proceedings. An example of some of the procedural protections, notice has to be given to the tribe of an Indian child who ends up in a state court child custody proceeding. Also, if there is going to be an effort made to take the child from the parents or the custodian, there has to be active efforts made to give remedial care and advice and rehabilitative efforts to the family. Do everything possible to keep the family from being broken up and actually having to remove the family. Then, if those don't work, and there actually is going to be a proceeding, a foster care proceeding, an adoption proceeding, the substantive standards imposed by ICWA require that, number one, there be an expert witness that testifies that in a foster care proceeding that the standards to take a child from a parent for a foster care placement is that there is clear and convincing evidence that keeping the child with his parents or custodians would be, as the statute says, likely result in serious emotional or physical damage to the child. If it's an adoption proceeding, the standards are even higher. There has to be evidence beyond a reasonable doubt. This is coming, including from an expert witness, a qualified expert witness, that leaving the child with their parents would likely result in emotional and physical damage to the child. Another target of the statute is to try to get as many child custody cases as possible out of state court and into tribal courts. So ICWA provides for a transfer of jurisdiction provision. And any tribe has the right to intervene and to seek transfer of a state court case to a tribal court. And if the court does not find good cause to the contrary, or there's no objection from parent, that's supposed to happen. There will be transfer to the state court. The statute also identifies what is existing case law was then and is now, that if a Indian child that ends up in a state court child custody proceeding turns out to either reside or be domiciled on the tribe's reservation, the child's reservation,
Howie, I don't know if everybody is experiencing this, but for me, you're frozen. Is that true for you too, Garrett? Okay. So if you can hear me, Howie, I will also text you, and maybe you can log back in. For everyone else, if you wouldn't mind just standing by for 1 second as we try to work this out. Okay, it's really been one of those days with the technology. So sorry about this all. Howie will be right back, and we will get back into the discussion. In the meantime, I will say, I don't see a Q&A function on my Zoom. This is another tech thing that we're working through today. But if you do have questions, please put them in the chat if you're able to send them to me. And okay, thank you. Somebody just texted me. All right, so now the chat should work now for you to be able to send me and the panelists a chat or a question, and we'd be happy to address those if there is time at the end. Hey. This experience is making me think I need something to like be showing when this sort of thing is happening. So like a little cartoon short elevator music, yes. So Garrett, unmute yourself so we can hear you.
Remember from the drive-in movie, the soda cup dancing around saying, going out to the lobby. So the audience, get some refreshments, folks. You know, you're going to need them.
That's right. Oh, yes. And Andy Perry just put something in the chat, Garrett, that you and Howie were talking about earlier, if you want to mention it.
Yeah, the PAO today announced that, or a few days ago announced that there will continue, even though oral argument is going back in person, and there will be an audience of spectators in the courtroom, the court is going to continue to live stream the oral arguments in real time. I was very concerned they would go back to the delaying releasing the audio till Friday, which was the old policy. But no, you know, if you want to get up at 7 o'clock, you can listen to the court's arguments as they take place on YouTube.
That will be awesome.
Yeah, breakfast with John Roberts.
That sounds okay. Well, I don't see why, Garrett, it wouldn't be okay for us to talk a little bit about the constitutional issues, or just in terms of the framework of them. And then when Howie's able to rejoin, we can return to the specifics of the ICWA and then the case itself. What do you think?
Yeah, that's fine. I think Howie's presentation should take precedence if it's available, because he has got, he's really understood the statute, and he has got practical experience dealing with this. As a con law guy, I cruise along at 50,000 feet, and I'm very interested in how the court is going to handle this. First of all, the court has got this case, which the Fifth Circuit screwed up beyond recognition. It was, even for that circuit, the least competent handling of a major case that I've ever seen. It's like reading one of those old common law English opinions where you have to make notes in the margin. It's like, Lord so-and-so said yes, Lord so-and-so said no. And you go through all the issues, and the vote count is different on each one, and there's 400 pages of opinions, and it just makes you want to hide your head in shame. But the questions that the court has granted cert on are three. And one of them is whether anybody really has standing, anybody in this case, any of these plaintiffs have standing to challenge the statutes, the provisions of the statute that are being challenged. The second is those provisions, and the two that are really under examination in this case are one, which is the definition of an Indian child. Obviously, the Indian Child Welfare Act has to indicate to whom it applies, and that definition is that it's a child who either is a member of a federally recognized tribe or who is the child of a member of a federally recognized tribe and eligible for membership. And the second is a provision that says that preference has to be given to the intact, the original Indian family, if possible, for a placement. If not, another member of the tribe that the child is eligible for. And third, if neither of those is available, for another Indian family, that would be a child of a family of a different tribe. And the argument that is made by the challengers is that these two things create racial preferences, which would require strict scrutiny. Now, one of the important background principles of federal Indian law is a case called Morton versus Moncari, which dealt with employment preferences at the BIA. And the court held in Morton that preferences for Indian people are not racial classifications at all. They're political because we have government-to-government relationship with the recognized tribes. And it's a little bit like our relationship to a foreign country when they're seeking something from us. We don't say, well, you can't give them the benefit they're seeking because that would be racial. It's a diplomatic thing. And some of that history is still present in Indian affairs. And then the third is a claim that some of the record keeping and notification provisions in the Child Welfare Act, which are really quite important, because the idea is that the state has an affirmative duty to let the tribe and the Indian parents know what's happening. And what's shocking is that state courts have routinely not done that. And even today, this provision is more honored in the breach than the observance in a lot of places. And parents will find their parental rights terminated without any notice. So there has to be notice, the tribe has to have notice, and the other thing is the states have to keep certain records, they have to make reports to the federal government, and they have to make efforts to keep the Indian family intact. And the argument is that this violates something called the anti-commandeering class doctrine, which I taught in my class earlier this morning. And I began by saying, if you have snores, prepare to shed them now, because students over the years have found this to be among the most boring parts of of constitutional law, but it could be quite important. And the commandeering principle basically says that Congress can't regulate states as states, which tends to mean the internal workings. The two major, well, there are three major cases. In one, Congress told Oklahoma it had to change its state capital because they, for whatever reason, wanted it to have a different state capital. And the Supreme Court said, "What, are you stupid? You can't do that." And then the second one was that the state of New York had to take title to some nuclear waste if it did not regulate to federal standards the disposal. Then the idea was, under federal law, you now own the nuclear waste and you're responsible for any damage it causes. And the court said, that's a sovereign act, that's a legislative act, taking title, acquiring property, and the federal government can't regulate the legislature. And then finally, the Brady Act required local sheriffs and law enforcement officers to conduct the background checks for handgun permits while the federal database was being put in place. And the court said that you can't order state executive officials to administer an entirely federal program. You can have cooperative federalism, you can offer incentives and so forth, but you can't just say, sheriff, go out and do this. Obviously, this would be extending the anti-commandeering principle quite a distance because the government's argument is, this is not a regulation of the states as states. It is a regulation of the child welfare system as a whole, which involves many players, not just the state. It involves private agencies, adoption agencies, foster care placement agencies, religious groups that are involved and so forth. And if you extend the anti-commandeering principle this far, the federal government is going to lose a lot of tools that it has for regulating not just Indian child welfare matters, but a lot of other areas, because this is a systemic regulation. States participate in the system, and the rationale heretofore has been that if you do that, you're subject to the general regulations that govern that. Now, a couple of things need to be said about this. One is this is an agenda case. This is a case that the conservative legal movement has been wanting to bring for a long time, for a wide variety of reasons. One is, I think, that the extractive industries are very eager to reduce tribal control over their land and affairs, because that will open up opportunities for timber and mining and oil and gas extraction on tribal land. The other is that a lot of conservative religious groups, a lot of religious right groups are very strongly opposed to the Indian Child Welfare Act as a whole, because they see their mission as providing good Christian homes for children who otherwise wouldn't have them. And to them, Indian children being brought into homes off the reservation by intact mom and pop families who will raise them in the church is strictly a gain for those children, because their souls will be saved. Finally, there is this overarching concern in the conservative legal movement that we can't have any so-called racial preferences in our law. We have to have total colorblindness, which means, do away with affirmative action and do away with a lot of things that favor Indians, including Morton versus Moncari. So the outcome of this case constitutionally is not going to produce those extreme results. But if if the court agrees to look at these preferences as racial rather than political, it is going to lead to further litigation to get other Indian preferences described as racial, and eventually to overturn Morton versus Moncari, which is unquestionably the aim of the movement. And so I liken it to your favorite sweater, Christmas sweater. You get it out every Christmas, and there's a little thread hanging, and you pull the thread, And by the next Christmas, all you have left is the collar because it unravels. Slowly, the entire system of relating to tribal members and tribal governments could be unrolled over time. Now, looking down the road, the lineup of justices is going to be really fascinating. We have the Chief Justice, whose experience in these issues was as counsel in a case called Rice versus Cayetano. And that was a challenge to a program that the federal government set up to create a council of Native Hawaiians that would supervise various programs that were involved in making some remediation to Native Hawaiians for the theft of their land, the destruction of their government, the overthrow of their king, and so forth. And only Native Hawaiians were supposed to vote in that election. This was challenged as violating the Equal Protection Clause. Chief Justice Roberts, who wasn't Chief Justice then, obviously, argued the case on behalf of the challengers and won, saying, that this is a racial preference. In that case, the court was careful to say, we're not talking about Indians. That's a whole different thing. But nonetheless, the Chief Justice has been very hostile toward anything that he considers a racial preference. Justice Alito is similarly very, very aggressively hostile to tribal interests. He he regards them as racial preferences. He wrote an opinion a few years ago about adoption of an Indian child under the Child Welfare Act that began, this case concerns a baby girl who is 1.2% Cherokee. So there's kind of, to me, a kind of chilling image of Justice Alito in his chambers calculating what he considers to be the percentage of Indian racial characteristic that this child had. On the other hand, we have Justice Gorsuch, who is from Colorado, from a Colorado family, was on the 10th Circuit, clearly knows a great deal about tribes and tribal sovereignty, and is a fierce defender of the prerogatives of Indian tribes and Indian people, and was able to put together a 5-4 coalition to find that most of southern Oklahoma was still part of the Muskogee Creek Nation reservation. But that majority has evaporated because Justice Ginsburg died and was replaced by Amy Barrett, who has not particularly shown much interest in Indian matters, is strongly influenced by religious concerns. So I think we're going to see sparks fly. And we put that against the fact that this court, in a case called Castro Huerta, which we're going to hear about, has shown the desire to completely redo Indian law. Basically, the court last term overturned one of Chief Justice Marshall's most important decisions, Worcester versus Georgia, and in favor of state authority. And they may just decide that states get to call the shots in child welfare matters and that the federal government has to exit. And that would pretty much roll up the Indian Child Welfare Act. So there's a spectrum of results that we can expect. And it's going to be really an interesting conflict within the conservative majority to see who comes out on top. With that, I'm going to give it back to Howie, who actually knows something.
Okay, it's so good to see you, Howie. Thank you so much for that, Garrett. So Howie's internet in Bend went out. So he is a superhero for getting back on somehow with his phone. Howie, if you want to unmute, I have your PowerPoint and I can share it for you if you'd like. But you have to unmute.
Mute.
This time, let's go out to the kitchen. Whatever that little snack song was.
Lobby.
Yeah, that's right. Out to the lobby. Have ourselves a snack.
Yeah.
All right. I mean, it's going to happen any moment.
Okay, can you
Hey,
hear me?
Yeah.
Yes.
Oh, sorry about that. Sorry about that. Okay, well, I was just describing, and I think I was pretty much almost through describing the kind of the key provisions of the Indian Child Welfare Act. And
Howie, should I project the slideshow?
yeah, why don't you?
Okay.
Go to the ICWA response slide. And yeah, I think I just got into the placement preferences, and which are the part of ICWA that says that if a state court child custody proceeding, a foster care proceeding, or adoption proceeding goes forward involving an Indian child, and that's defined as a child who's an enrolled member of a federally recognized tribe, or a child who's eligible for enrollment in a federally recognized tribe and is the biological child of a tribal member. So either a member or closely affiliated and soon probably to become a member is the definition of an Indian child. The placement preferences, which are also targeted by the plaintiffs in this case, say that if there is going to be a foster care placement or an adoption placement, there are preferences. The first preference is the child's extended family. The second preference is the child's tribe, somebody in the child's tribe. The third preference would be other Indian families. The court can, for good cause, depart from those preferences, or a tribe can, by resolution, suggest a different set of preferences. But those are the preferences in the statute. So take the next slide, please, Jen. This is an overview of the case, and maybe Garrett had talked about this a little bit. It started in the state of Texas, including the state of Texas, filing suit in a federal district court in Fort Worth, Texas. I think it was the same district court that had declared certain aspects of Obamacare, the Affordable Care Act, unconstitutional. The plaintiffs are challenging a whole set of provisions, as well as the entire statute, the Indian Child Welfare Act, as facially unconstitutional. One claim is that the entire statute is beyond the authority of Congress to legislate. Congress just does not have the power under the Constitution to legislate in this area, in a statute like the Indian Child Welfare Act. The next claim, which is equally broad and potentially destructive, is that the Indian child definition and other provisions of ICWA that relate to Indians and Indian families and Indian children are racial classifications. And because they're racial classifications, they're suspect and they're unconstitutional under the equal protection component of the Fifth Amendment's due process clause. Then they also attack, based on the anti-commandeering doctrine and the non-delegation doctrine, certain aspects of ICWA relating to preferences and procedures and so on. They also attack the regulations adopted by the Department of Interior in 2016, which are mandatory and binding, implementing ICWA. So all of that was on the table in the lawsuit. It went to the district court, and the district court found for the plaintiffs, the Brackeens and other plaintiffs in the state of Texas, on all counts. That went to the Fifth Circuit three-judge panel, and the three-judge panel in the split opinion reversed all of the district court's granting of relief to the plaintiffs. The plaintiffs then sought en banc review by the Fifth Circuit, and the en banc decision was quite amazing. Jen, you can go ahead and go to the next slide with it. Oh, there you are. You're at the en banc ruling. It's huge, 325 pages, 16 judges participated, 7 opinions. And by and large, the federal defendants and the intervener tribes won most of the key rulings in the en banc panel of the Fifth Circuit. The majority rejected the Article 1, which is there's no authority to enact ICWA, and the equal protection challenges. The court held that properly, I believe, that the Indian child definition and the other categories regarding Indians set out in the statute are political classifications. They are based on membership in a federally recognized tribe or a close affiliation with membership in a federally recognized tribe. And those are political classifications, not racial classifications. And they are constitutional as long as they are rationally tied to the fulfillment of Congress's unique obligations toward Indians, the trust responsibility. The court went on to say, the en banc panel, that most of the provisions of ICWA presented no anti-commandeering problem and did not violate the non-delegation doctrine. And also the bulk of the ICWA regulations adopted by the Interior Department were valid. There were some aspects of the en banc decision, different majorities either struck down or affirmed the district court judgment by equally divided votes regarding certain applications of ICWA under the anti-commandeering doctrine, and those were struck. And also certain aspects of ICWA violated the non-delegation doctrine. So that was the outcome of the Fifth Circuit. Then we're now in the Supreme Court, and all sides of the case filed cert petitions on all issues, and the Supreme Court accepted cert on all issues from all parties. Here's the alignment of the parties in the Supreme Court. The plaintiffs are the Brackeens and other non-Indian individuals, I think 7 altogether, that are seeking foster and adoption placements of Indian children. There are some standing issues and case or controversies issues that are lurking in this litigation raised by the defendants. The state of Texas is the only state left in the Supreme Court. Indiana and Louisiana participated below, but they dropped out. The defendants are the Secretary of Interior and other federal defendants, and 5 tribes have intervened in the proceedings below: Navajo tribe, the Cherokee Nation, the Quinault Indian Nation, the Oneida Nation, the Morongo Band of Mission Indians. The amicus briefs present an interesting picture of the litigation. For the state of Texas and the Brackeen individual defendants, have been 8 amicus briefs filed. And it's pretty standard sort of set of conservative legal activist organizations, Pacific Legal Foundation, the Goldwater Institute, and so on. But the tribe's list of amicus briefs is astonishing. 21 amicus briefs have been filed in support of the federal and tribal defendants. And the list is kind of incredible. There's an amicus brief, joint amicus brief, filed and signed off on by 497 tribes. There are 575 federally recognized tribes in the country. So this is a huge chunk of all the tribes in the country have joined in this brief, plus 62 Native organizations. There are a couple of states on Texas's side, but there are 23 states and the District of Columbia that joined the tribal and the federal defendants side. 87 members of Congress have their own brief. There's an Indian scholars brief that kind of remarkably I've been able to sign, even though I'm not a scholar. I'm a teacher and a practitioner, but my name's on there and I'm proud of it. It's a great brief. Other scholars, administrative law, constitutional law scholars have their own brief. And you can go on and on. Senator Abarisk of South Dakota filed a brief. He was the sponsor of ICWA back in 1978 in the Senate, and so on and so forth. So that's the lineup of amicus briefs. It reflects the importance of this case and the stakes. The stakes are huge from the tribal perspective. So that's what I was going to present before I got knocked off the internet by my provider here in Bend, Oregon. And so, Jen, take us back to where we were before I jump back on the discussion.
Okay, great. Thank you. That was great. So I think what we had done, Howie, just so you know, is that Garrett had talked a little bit about the case. He continued to sort of flesh out a little bit of the background of the ICWA, and then discussed the constitutional issues at stake. So we have time now for a bit of a discussion. We do have some questions in our chat, and I just want to kick us off by asking you both to opine on this question. When Howie first described this case to me, he said it was, one of the biggest and most important cases that he'd ever come across. That it was going to be huge. And so I wonder if you two could speak about what do you think makes this case so important? I mean, we've already heard a little bit about. Obviously, it's going to affect the lives of the people involved, but we've heard some about it being an agenda case, et cetera. I mean, what kinds of impacts do you think a ruling for the Brackeens in Texas would have?
You want me to go first?
Yes.
No. First of all, I think the claims brought by the plaintiffs are breathtaking, really dramatic. they sort of narrowed down to some lesser claims regarding non-delegation doctrine and so on. But the Article 1 claim, the claim that Congress does not have the power to enact legislation like ICWA, is dramatic. Congress's power in Indian affairs, it's in the Constitution. It's part of the Commerce Clause. It's also a function of the Treaty Clause. It's a function of the Trust Responsibility Doctrine, which is an extra constitutional source of authority, and generally has been held to be over and over and over again by the Supreme Court a plenary power, a power that's broad, very broad. And Congress has been enacting statutes regarding Indians since 1790. And it's just unthinkable that a statute like ICWA would be beyond the power of Congress to enact. It's clearly pursuant to the trust responsibility, which is embedded in the foundation principle of Indian law, first articulated by Chief Justice Marshall in the Cherokee case in 1831. And that's the nature of the relationship between the federal government and the federally recognized tribes and the members of those federally recognized tribes. It's also found in treaties between the United States and tribes that led to the opening up of Indian lands. That was part of the quid pro quo, was that the federal government would assume a duty of protection for tribes going forward in exchange for the tribes ceding title to their lands to open them up for settlement and so on. So to think that Congress somehow doesn't have the power that the Constitution says in the Indian Commerce Clause they do have to enact a statute like this is really beyond the pale. And if it's successful, that calls into question the constitutionality of hundreds and hundreds and hundreds of statutes going back to 1790 that single out Indian people for special treatment. And sometimes it's good treatment, sometimes it's bad treatment, but it's within the plenary power of Congress to give them that treatment. The second claim regarding equal protection is potentially equally as devastating if it's successful. Morton versus Mancari in 1978 and other cases have long held that Indian status is not a racial status, it's a political status. And legislation relating to Indian tribes relates to them as political bodies, semi-sovereign political bodies who have a special relationship to the United States. And those semi-sovereign political bodies are made up of enrolled members of those tribes. And to single out those members as a race and as a racial classification is potentially equally as destructive and essentially existential. And not only in terms of the statute itself, the Indian Child Welfare Act, which is a hugely important statute to Indian tribes and Indian people, but the whole body of federal Indian law. If Indian statutes, Title 25 of the United States Code, are suspect because they legislate for racial classifications and people rather than political classifications, which are justified by the trust responsibility, then that entire body of statutes and really common law for over 2 centuries is cast. The question is, does it exist anymore after a decision that would find that there is equal protection problems with the Indian Child Welfare Act, or it's beyond Congress's authority? So those are kind of my views on the overall overarching importance of the Brackeen case.
How about you, Garrett?
Well, I think one of the points I try to make from my 50,000 foot altitude is that if you reframe how you think about the federal government's relationship to tribes as a matter of sort of international diplomacy, the whole political versus racial thing becomes a lot clearer in the following sense. Last term of court, we had a case called Golan versus Sada that involved the return of a boy born in Italy to an American citizen and an Italian citizen who had been brought to the United States by the mother in violation of a custody decree or a pending custody decree in Italy. And so the question for the court was, under the Hague Convention on International Child Abduction, who did the child have to be returned to his father in Italy, or could he remain with the mother in the US because she feared that there would be abuse if he was returned? And if anyone had injected an argument into that said, well, you can't return the kid to Italy because that would be a racial classification. You're favoring the Italian race. I think, nobody would have listened to that for 5 minutes. They would have just said, what are you, nuts? Italy is a country. We have this treaty that obligates us to do these things, and we need to carry it out in good faith. If you reframe it and realize that Indian tribes came into the United States as sovereign nations, that were some of whose sovereignty was absorbed by the United States, but still have been involved since, as Howie says, since 1790, in government-to-government relations, diplomatic relations with the United States, then the question of who is a tribal member does not present a racial question. And I saw one of the questioners said, well, what about tribes that have a blood quantum, right? You can't be members of the tribe unless you have some percentage of actual descent from a member of the tribe, 25% or something like that. Not all tribes have that, but they certainly do. And I'd say, again, what if this were another country? Members of my extended family are of German descent, and some of them are involved in trying to qualify for German nationality. I think everyone is thinking that it might be handy to have a spare passport, but one of the things Germany asks is, are you descended from a German citizen, right? Well, no one would say, well, the German race is making racial or racist classifications against potential citizens. Countries have the right to have a blood requirement. And there's a lot of agitation that the United States should have one, and the 14th Amendment should be scrapped and so forth. That's not a racial classification. It's political. It flows from the domestic law of the other country and the international law that we are required to follow. And I think the reasoning of Morton versus Mancari is very much the same. The reason why a member of an Indian tribe can claim certain preferences offered by Congress is because of citizenship, not race. And unfortunately, I think the idea that this is racial is very persuasive to the court. It seemed to me if you wanted 9 elders to decide a question about Native matters, the 9 members of this Supreme Court would be the last elders on earth you would choose. They don't know what they're doing, and it's very concerning that they have the authority to make these decisions. Now, part of Howie talked about the claims, the maximal claims that are made in this litigation, and I think that we are not going to see the court bite those claims, but I think that they are there in part to shift what's called the Overton window and get people arguing about this, so that when the court makes a decision that is very adverse to tribal authority and the Indian commerce power, people would say, oh, the court took a moderate course. It's the John Roberts approach, which is, I'm only going to cut off half of this. That's very moderate. So again, I think of it in terms of the Christmas sweater, and I'm very concerned that some unraveling will take place.
Okay, so just looking at the questions, thank you for this, both of you. Well, a quick kind of fact question: is Oregon in one of the amicus briefs?
Yes,
The state of
yes. And Oregon also has its own ICWA statute. A lot of states do. Washington does as well. There's an Oregon ICWA. Yeah.
Okay, and do we know why Indiana and Louisiana dropped out? Is there a sense of why that happened?
I do not know.
Okay, interesting. All right. So here's a question. The United Nations recognizes the removal of children from a culture as a form of genocide. If ICWA is overturned, is there a possibility of significant international backlash to the United States?
Professor Epps, want to field that?
Well, I think I have two thoughts about that, which are somewhat disjointed. But the first is, if you look, you put on a very good presentation in brief of the numbers that, the impact that these unrestrained state foster and adoption policies were having on tribes. And they really, I think, would in natural language seem close to genocidal, where enormous numbers of children are being taken from their parents and raised in the other culture, in significant part because the people making those decisions think of the other culture as superior. And so, yes, I think that this can be argued in genocidal terms. Now, as to the question of international backlash, I have to say that I don't think that the majority of this court is very concerned about international backlash. We've had an international backlash to Dobbs, the case that overturned Roe versus Wade, and enormous amounts of criticism from around Europe and other countries. And the response was Justice Alito, who went to Rome and made fun of these leaders, made a joke out of it, and then said that Boris Johnson had lost his job as Prime Minister of Britain because he criticized Justice Alito. So I think that, this court has got the bit in its teeth. And the question is, how far do they want to go? The final thing is, I think that it's appropriate and necessary to argue, that the concrete results of an adverse decision in this case would bring problematic phenomena on the reservation. But all the indications from last term are that the court no longer considers the concrete results of its decisions to be its business. In Dobbs, they said, some people say that this will be bad for women, it'll hurt their lives. We don't know. What are we? We're just the court. We decide these abstract issues. Women can work it out. Goodbye. So I think I fear that, and I hope that someone does a good job of bringing home to members of this court that we're really dealing with the lives of people and the survival of Indian nations.
Jen,
So-
could I ask
Yes,
Eric
please.
a question?
Please go ahead.
You may have already addressed this while I was off of Zoom, unfortunately. Until recently, Justice Gorsuch has become a real leader in Indian law on the court. And until and up through 2020 and the McGirt decision, he was able to muster a 5-vote majority in favor of tribes and tribal interests in Indian law cases, culminating in the McGirt decision 2 years ago. But it's the Castro Huerta decision shows us that he no longer commands that majority. He led the 4 votes and wrote the dissent that failed to persuade the majority of the court. So if in Brackeen, the Indian Child Welfare Act is going to survive, at least in principle part, where is the 5th vote going to come from? Who's going to join Gorsuch and the 3 other justices who sided with him in Castro Huerta? I think we can count on them as reliable pro-tribal votes in Brackeen. But where would the 5th vote come from?
One of the 3 is gone, but Justice Jackson, who took Justice Breyer's place, I think, is probably sympathetic to the tribe's concerns. Well, the interesting thing in the background is that 2 of the 9 justices are adoptive parents. And Justice Barrett, is the natural parent of a certain number of children. And then the adoptive parent of a child from Haiti. And so, how is this going to influence her view of whether it's a good idea to take a child out of an impoverished or stressed background and bring them into Anglo society? I have a suspicion about it, but I also think she's a very intelligent person, has on the whole, a good heart, and maybe could be swayed in this context. I do think Justice Kavanaugh has signed on with Justice Thomas in a kind of burn it all down approach to Indian law. If you read his opinion in Castro Huerta, he basically says, we're not, Indian tribes aren't entitled to any special consideration. It's all state authority. And, the implications of that are very far reaching. It certainly suggests to me that Kavanaugh is not up for grabs. So, keep your eyes on Justice Barrett.
That's what I was thinking too. And someone in the questions just mentioned the Dobbs line about the domestic supply of infants. There is that in one of the footnotes, I think, this sense of having more infants up for adoption being something of value that would come from the decision. And this interesting kind of adoption agenda kind of running through the court right now. Okay, so someone has asked, could you comment on the possible impacts to Oregon's ICWA if Texas and the Brackeens are successful in the Supreme Court? Would it have any impact on our state law?
That's got Howie's name on it.
Well, partly your name as well. That's sort of kind of reminiscent of the Smith case, and that you wrote a book about, a great book about the peyote case in the Native American church that went from the Supreme Court back to the Oregon Supreme Court, U.S. Supreme Court, then back up, and then finally. So it, I would hope that it would exist. It would stand. It wouldn't be struck down immediately. Garrett, would that make it vulnerable under a constitutional challenge under Oregon's constitution, or is there enough differences?
As far as the Article 1 challenge, I don't think so. I think that the state's authority to deal with Indian tribes within their border is not on the skyline in this case. But if we begin to say certain Indian preferences are racial, the Equal Protection Clause is homologously binding on states as it is on the federal government. And so that to the extent that the Oregon Indian Child Welfare Act contains preferences for Indian tribes or so forth, I think we could anticipate litigation. And I think, one of the interesting things, Matthew Fletcher, who's going to be our Bernard Strickland lecturer, has written a fascinating article called Lawyering the Indian Child Welfare Act. And one of the points he makes is that the opponents of the act have enormous amounts of money behind. The Koch and Mercer fortunes are behind these conservative groups. Whereas for ordinary practitioners to take on one of these child welfare cases from the point of view of the tribe is less lucrative. There is no fee shifting statute for these, unlike civil rights cases and so forth. So, there's going to be so much litigation. It's going to be like, incoming missiles, Sonic the Hedgehog trying to catch them. And, what will come of that, I don't know.
Okay, so gosh, it's fascinating, and we'll be watching for sure to see what happens in November. We're almost at the end of time, and so before we end it, I just wanted to thank so much our panelists, Professor Epps and Professor Arnett, for participating and sharing their expertise with us. It's been fascinating. I also want to thank you, our wonderful audience, for being so gracious and patient during our technical problems. Thank you. And if you are looking for CLE credit, be on the lookout from us for an email seeking your bar number. I hope you have a wonderful rest of your week, and thank you for joining us today.
Jen, I promise never to rely on Ben Broadband again.
Ben Broadband is in the doghouse.
They are in my doghouse for sure. So I'll do this from the law school.
I'll see everybody tomorrow.
Yes, see you tomorrow, Garrett.
See you tomorrow then. Thanks. I'll be there.
Thanks, everybody. Bye.
Thank you. Bye.